All right, well, good afternoon, everyone. Welcome to our technology series presentation. This is going to be an overview of key issues in the technology services and licensing agreements. We appreciate you spending your time with us today. The goal of this series is to provide regular updates on issues and trends that impact the technology industry. To that end, please mark your calendars for January 24th. We'll be presenting on emerging trends and recent developments in employment law. Before I introduce today's speakers, a few housekeeping items. First, we are recording the program. A recording as well as an electronic copy of today's presentation will be available in the next several days. Next, for our online participants looking for CLE credit, we're going to have 2 Zoom polls. Please verify your attendance by responding to the polls when they populate. Finally, time permitting, we will answer questions at the end of the presentation. The best way to submit a question if you're not in the live audience is through the Zoom chat feature. I'm going to be monitoring the chat throughout the presentations and we'll collect questions. If we're not able to get to your question, a member of our team will follow up with you after the presentation. I'm now thrilled to introduce our panel comprised of several members of V&E's Technology Transactions team. This group, together with other members from across the firm, provide a full range of integrated services to clients developing and selling technology, offering technology-enabled services, or using technology to improve operations and to better serve their customers. It's my pleasure to welcome partner Michael Kurzer and associates Alexa Chawley and Haley Tickham, and enjoy the presentation.
Hello, good afternoon, everyone. I'm Michael Kurzer, and to my left is Alexa Chawley, and to my right is Haley Tickham. So the presentation today is going to cover a lot of ground. We have an hour, so this could easily cover 24 hours worth of subject matter. But we've said we're going to focus on technology services and licensing agreements. What we're proposing here today is a kind of a methodology of how you might review agreements when you receive them or when you're asked to sort of prepare something. And this could be typically in the perspective of, you have a vendor agreement that you want to review, or, maybe you have a company that offers products or services, you need to prepare a customer form or terms of use or general terms or these types of things. Or, you have something more complex, whether it's a license agreement or a partnership agreement, a JV agreement, something that might border more on an M&A type transactional document. We're going to kind of stick to the more commercial tech and license service type agreements, although there's a kind of a continuum as this can sort of expand out and they can either be ancillary agreements to deal to deals, or they can sort of survive on their own. So getting into it here, there are kind of 3 broad general categories of tech and license agreements that we're going to cover here today. The first category is form agreements or off-the-shelf terms and conditions. So these are, you can kind of see the examples up here. These are terms that, you often can't negotiate, and we'll kind of get into what you might do or how you identify when you're in this situation. And it's not always the case that you're not able to negotiate these, but it tends to be a tougher, a tougher proposition. The second broad category of agreements that we're going to cover today are what we're calling negotiable form agreements. These are the kind of the bread and butter agreements that operate for most of the services if you're paying for and signing a contract. Where the first agreement might be click through or even browser app, maybe you're not even signing a document in order to get the services under a contract. This group of documents, is kind of the bread and butter of what we in this group negotiate for majority of our clients. And this, these kind of run the gamut. But there's, in the master service agreement structure, there could be all sorts of attachments and addendum that hang from that: statements of work, purchase orders, change orders, data processing addendums and agreements. And then, we've also included in this that are not so, engagement letters, or could even include some employment agreements, could even be within this category, contractor agreements, those things that also touch on technology and IP. If you bring somebody in who's got technology that you're going to use as part of your company, you might have one of these types of agreements that you negotiate as part of that. And then the last category that we're going to cover, we call bespoke agreements, only for lack of a better word. I think the word bespoke is not, I think when we hear that, it doesn't sort of, roll off the tongue easily. But what we're getting at here are kind of customized agreements where every single term in the agreement is at play or being negotiated, that it's not as if you're getting a form and you're going to flip 3 or 4 provisions out of it. You're pretty much looking at every single provision. And if you have the opportunity, it's, from a legal perspective, usually best to have the drafting pen in your favor to kind of, get the terms anchored and to establish, how the negotiation is going to go. And these agreements, we do a lot of them as well. And they, we've got some examples on this list here, but really it can go a lot broader than what you see here. In any event, I'm going to send it over to Haley for the framework of the review.
Thank you, Michael. So now that we have a little background on the categories of agreements we're looking at, let's do a quick run through to see how you may want to approach them if they come across your desk. So the first thing you want to do is determine the category of agreement that Michael just went through. So essentially, how negotiable do you think this agreement is? Then you want to identify the key terms and considerations that you want to address. And then the next step depends on the type of agreement. If it's off the shelf and not negotiable, you essentially have 2 options. You either move forward with the agreement or you consider alternative products or services. If the agreement is negotiable, at least to an extent, you can prepare your issues list or markup. And if the agreement is going to be bespoke, then someone needs to provide a first draft. And like Michael said, often if you take the pen, you can anchor the terms and set the tone for the negotiation. Backing up just a little bit, Michael gave a little bit of intro on the different types of agreements that we see here. But how do you know what kind of category it falls into if something comes across your desk? And this, of course, varies by situation and varies by agreement. But these are some general guidelines of the kinds of things that we tend to see in each type of agreement. So, for example, for off-the-shelf agreements, these tend to be, vendor favorable and one-sided, and there may not be a place to sign. For negotiable form agreements, these typically have higher fees, and they may include deadlines or schedules of work and deliverables. And then this third category, these bespoke agreements, these can relate to specialized roles or services. They sometimes have exclusive arrangements, and they may be larger in scale or relate to custom IP development or use. So once you determine how negotiable the agreement is, you may want to look to these high-level considerations. And these are not key terms per se. They're more like considerations you may take a lens viewing the contract with. The first and one of the more important things is what's your negotiating power and leverage, and who's the counterparty. So for example, if a university is the counterparty, they may not be able to give you certain rights. Or if you're going to be a large customer and spending a lot of money, you may have additional leverage. Another thing to consider is whether the agreement is a one-off or if it's a series of agreements. This is important because if it's a series of agreements, what you negotiate now could set the tone for future agreements. Is there any friction involved in acquiring the product? If you're a customer and it would be difficult to transition away from the service or product once you sign, that's something that you want to consider and make sure the terms are what you need at the time. Industry standards are also important. So low-cost, off-the-shelf solutions usually come with standard terms that you can't negotiate, but you could at least benchmark and see what the other competing products and services are that are out there and what their terms are. The other thing is key liabilities. So all agreements have inherent risk, but are there any special considerations that may affect the liability or be unique to the type of agreement? So for example, if there's sensitive data collection, that could impact liability, and you have to determine who takes on the liability for a potential security breach. So now that we've discussed kind of the general framework, I'm going to give a brief overview of some key terms that you may see in these agreements generally, and these apply to agreements across the board. Later in the presentation, we're going to look at how some of these key terms might apply in the context of any specific types of agreements. So we're going to look at IP ownership, allocation of risk, confidentiality, data privacy, and security, and then we're going to touch on some other considerations as well. So for IP ownership, most, if not all, technology services agreements are going to involve IP in at least some way and often in multiple different ways. And this is IP as it relates to who owns the IP, what the background IP is, what happens to newly developed IP, and if there's any third-party IP involved. So if you're viewing an agreement as a customer, the key thing here is to make sure you're getting access to all the IP you need while still protecting your own IP. And if you're a vendor, you want to make sure you have the rights to use the customer's IP if needed. And you want to make sure that whatever IP you assign to the customer, you either don't need or you at least have a license if you want to provide it to another customer in the future. So the important thing here is to clearly lay out what the IP is, who owns the IP, and what happens to any newly developed IP. So going back, let's say that you're a customer. What IP rights do you need as part of the receipt of products or services? If you're not going to be receiving ownership, you need to make sure you have a license of an appropriate scope. And what do we mean by that? It's basically what IP do you need now and going forward? So do you need the license to be perpetual? Or is it okay if it's only during the term of the agreement? Or maybe certain aspects of the IP you need a perpetual license in, maybe deliverables, for example. Do you need the rights worldwide? Or is it okay if it's limited to a certain territory? Do you need to be able to sublicense the IP? And if so, to who? Do you need the IP generally, or is it okay if it's limited to a certain field of use? Also, the specific arrangement may influence how you go about the agreement. So for example, if you're investing a lot of money into building a plant or a product using another party's IP, then maybe you really want to make sure that that license is perpetual, even in the event of breach. Maybe you're willing to pay additional fees, but you need to nail down those IP rights. The type of IP being licensed also determines what rights are available for use. If you kind of think back to law school and thinking about property as being a bundle of rights. So for example, if you're looking to license a patent, maybe you're considering whether you need to make, use, sell, offer to sell, or import. And if it's copyrightable material, maybe it's use, modify, copy, perform, or publish. On the flip side, if you're a vendor, you need to make sure you do not give up too many rights. So for example, if you're providing a service to a customer and you're developing IP, if that customer is going to get ownership of that IP, you need to make sure you don't need to provide that IP to other customers. Another thing you need to consider is that you have the proper access and rights to use your customers' data and IP. So frequently we like to think about these as one-way licenses, where if you're a service provider, you're providing a product or service that the customer needs IP from you. But it's very common that there's actually a license to the customer IP or data as part of that agreement. The other thing is what happens to newly developed IP. So joint ownership can be very messy, and so it's typically better to clearly lay out in the agreement which party owns and provide the other party an IP license if necessary. Typically, as a viewpoint, if you are the owner of IP, you want to give out as few rights as possible. And if you're not the owner of IP, you either want to get ownership or at least get the broadest license that you need or you can negotiate for. And another consideration is third-party IP. If any IP is needed or that is owned by a third party. We see these frequently with software agreements when third-party software is needed. So if you're a customer, you need to determine what third-party IP you need and how you're going to obtain those rights, whether the vendor is going to pass those rights through to you or if you have to go out and seek your own licenses. Moving on to allocation of risk. This is obviously a huge consideration that's affected by a lot of terms throughout the agreement. And your risk profile can be influenced by warranties, liability disclaimers, caps, exceptions, indemnity, remedies, and the like. It almost goes without saying, but each party is going to try to limit their risk, both financial and otherwise, and this can take many forms. So for example, providers will want to disclaim warranties and limit their liability as much as possible, and warranties themselves can take many forms. So for example, there could be a general warranty, for example, compliance with law, and these are often mutual. And there can be specific warranties as well. So for example, if a provider is warranting that they're performing the agreement or that they're going to build the products in compliance with the specs. One thing to be very careful of is the language in warranties and relatedly indemnity. And this is because if the wording is not precise, it could sweep in additional things. So for example, if you provide a warranty that you're in compliance with law, that could sweep in data privacy laws. Or if you're providing a warranty of non-infringement or that you have the rights to third-party IP, that could sweep in open source software issues. Non-infringement in particular is often a sticking point we've seen when we're negotiating these agreements, especially as it relates to warranties. And that's because it's really difficult to quantify infringement risk, especially as it relates to patents, because it's hard to know what else is out there. And even if vendors agree to indemnify for infringement, they frequently don't want to provide warranties. The difference being maybe they're willing to defend or provide non-infringing materials, but they don't want to be on the hook for direct damages or allow for the other party to terminate for breach of the agreement. And not only can you seek to limit your liability by providing limited warranties and indemnities, but you can add in exceptions and provide for caps and limited remedies. So for example, say you're providing a non-infringement warranty, but you want to carve out from that if the other party, say the other party is a customer and they give you instructions or specs that they want to build you, they want you to build a product in accordance with. And then that ends up infringing a third-party IP. Maybe you want to not be on the hook for that and carve out your liability as it relates to third-party counterparty instructions. Another thing is limiting your liability, and we often see this as above a certain threshold. So for example, to the fees paid under the agreement or some multiple of the fees paid under the agreement. More importantly, I think one thing that we often don't think about when we're looking at these agreements are other ways to reduce your risk that don't have to do with the terms of the agreement or the language. So mitigating risk outside the contract. So for example, if you're a software company and you're providing code, maybe you do a black duck or similar scan to look for open source software. Or if you are licensing in software, maybe you want to partition it from your other code to just, in case there's any copyleft issues, you're not tainting the rest of your code. Another thing, for example, is if you're bearing the risk for compliance with data privacy laws, have you done any penetration tests? Have you done any third-party security audits? Have you tested the security and integrity of your systems? Have you looked into cyber insurance? There's a lot of ways beyond just the contract that you can address risk with these types of agreements. Another set of key terms relates to confidentiality, data privacy, and security. These terms are increasingly a sticking point between parties because there could be large liability. It's really difficult to determine compliance sometimes, and because the laws have been constantly changing in this area. the first question to really ask here is what data is being collected and accessed and whether any of it is sensitive. And then once you know what the data is, you can address it accordingly. So for example, if there's personal information that needs to be shared, you should get a data processing agreement or addendum. Relatedly, if there's protected health information, then you should get a business associate agreement. And then the other thing is making sure there's the proper ownership in place and that data was collected in accordance with law. The other thing to clearly lay out in the agreement is what happens in the event of a data breach or an incident. So this can include things like procedures, notices, and the remedies. The other thing that's really important that I think sometimes is overlooked is compliance with your own privacy policies. So beyond just what you're supposed to be doing under the law, if you have a public-facing privacy policy that says that you're doing certain things, you don't want to not be doing those certain things because that's how companies get into trouble sometimes. And then while it's sometimes difficult to determine whether or not your counterparty is doing what they're supposed to be doing in the agreement, whether they're taking the steps that they said that they would to protect your data, depending on the type of agreement, who the other party is, the type of data involved, you may be able to perform audits or negotiate to perform audits or be able to get from them proof of certifications or other things that they're supposed to be doing to make sure your data is protected. Here is just a short list of additional terms for consideration. Of course, this is not exhaustive, but these often are also very important terms across the broad spectrum of agreements. So we previously mentioned third-party software or products and open source software. So is there any sort of other third-party IP that you need? If there's open source software, who's going to bear the risk for any copyleft restrictions? Term and termination is very important as well. How long does the agreement need to be for? Can you get out of the contract easily? Do you want the other party to be bound by the contract and not be able to get out of it easily? Do you want to provide for early termination fees? So for example, if you're a customer and you have a critical service that's being provided to you, you don't want that vendor to be able to easily terminate the contract. Or if they can, you want to at least have enough notice and maybe they need to be on the hook for reasonable transition services. The other things you may consider force majeure, what happens, when things outside the control of the party happens, or change orders. What happens if you want to order more products or you want to order fewer products? If you're a vendor, do you want to have to comply with these obligations or do you want an approval right? Access is also very important. Will a party need to access the other parties' systems? And if so, what procedures and controls and security will be in place to make sure that any data is transferred in compliance with law or that the data transfer is safe? Insurance for one or both parties. Does one or both parties need to obtain insurance? If so, for what and how much? Assignment and change of control. Do you need to be able to sign the contract? Do you want to prohibit the other party from assigning the contract? What happens if there's a change of control of your company or the counterparty? And then, of course, we hate to think that anything would go wrong with our contracts, but in the event the relationship sours or something happens and you're looking at litigation, what's the governing law going to be? What's the venue going to be? Is it can be subject to arbitration? So now I'm going to pass along to Alexa, who's going to talk about key terms by agreement type.
Awesome. Thank you, Haley. So next, we're going to put those key terms into context and some of the typical tech agreements that you're likely to see. So these are the tech agreements that I'm going to go over. You'll form end user license agreements, or EULAs, your TOUs, MSAs and SOWs, license and data sharing agreements, and then consulting agreements. And each of these, you should be sure to focus on a handful of key items. And you're also going to want to take into consideration your counterparty and what you need from them, and then how your role is going to change depending on where you sit in this agreement. So starting with our Category 1 agreements, these are our form agreements that you're probably not negotiating. If you are, it's going to be focused on high-level issues. Even if you're not negotiating them, there are a few high-level items that you should still take a look at when you sign up for this. So starting as a customer, first, you'll want to consider your scope of your license. Is it, I mean, at a base level, is it to the product that you think you're buying? Does it cover what you think you'll need to use the product? Is it limited by jurisdiction or territory? Who are the IP rights provided to? How long does it last? Are there any other limits within that? Sublicensing limits, other transfer limits? What about use rights? Are there any limits on how you can use the product? Is it limited to certain individuals within your company or certain personnel? Is it limited to seat licenses? Sometimes we see that. It's like a per seat arrangement for payment, and then you have to account for your accounts and how many people are signed up to that platform. And then is your vendor determining your seats through an audit? So you want to be sure that you're in compliance with your seat licenses in case you get audited. And then also what happens if you are audited. If you're licensing any data, then who owns the data that's coming out of that license? If you're a customer and providing data to a platform, like you're uploading your information and your data and analytics to a platform, whatever is coming out of that platform, like reports or other analytics that you use in your business, are you able to own that? Can you share it outside of your company? Sometimes we see, for example, customers wanting to share reports with other customers that they have to show, like here's what our product is doing or here's what we can do. So you want to be sure that you have the ability to actually share that information outside of the platform that you're receiving information from. And then sometimes you'll have to provide a license back. So that's something we can talk about later. Like Haley mentioned too, you want to understand what is going to terminate your right to this license. Are you able to, in the agreement, if for some reason the platform like isn't useful anymore to your business, or you have an issue with the vendor, when can they terminate your license? And then what happens on termination? So sometimes we see, for example, if you are providing a lot of data into a platform, sometimes the vendor will give you like a 30-day period after termination to download your data. And that's just a nice way to make sure that if there's anything important that you uploaded, you can still take that with you after termination. Another piece that may be included in these form agreements is other terms like service level agreements or information security policies. Oftentimes you'll see these hyperlinked in a terms of use or in a EULA. So definitely look in to see what else is linked to that agreement that's not actually listed there. And then keep an eye on those because those can change since they're linked. If you're talking about these agreements from the vendor perspective, in addition to kind of flipping some of those issues around, other items to consider are if you're providing a scope of license as a vendor, you may want to limit that license to jurisdictions that you're actually comfortable that you're in compliance with. So for example, say personal data will be uploaded to your platform. You may want to limit your customers from providing any personal data that's acquired outside of the US, because that could now start to trigger foreign data privacy laws, and that may not have been something that you prepared for or want to be subject to. Another issue on the vendor side that's a little bit different here is the data ownership issue. And sometimes a vendor may want a license back to any customer data that's provided into the platform. You may want that license to be able to improve your platform and use that data within your own analytics system and your own reports. You may want to be able to provide, so if you're a vendor and you receive information from a customer, you may want to be able to provide that information to another potential customer to show them kind of how people use your platform. So you want to make sure that you have the rights and hedge that accordingly, depending on what you're providing. So moving on to MSAs, these are really common to see, and these are kind of your category 2, sometimes category 3 agreements that you can negotiate more. I like to think of an MSA as the MSA itself contains your master legal terms that govern your entire relationship with your counterparty. And then your statements of work and the other exhibits are more non-legal. Sometimes they have legal, but usually non-legal terms that govern each engagement. So that could be phases of a project or components to something that you're developing. Like in software, we see that as like phase 1, phase 2, phase 3 of developing a platform, and that can look differently. So the master legal terms will live in your MSA, and those will cover some of the key terms that we've talked about that Haley went over. So starting with IP terms in MSAs, if there is any IP that's developed under an MSA, say you're contracting as a customer to receive a custom software component developed for your platform. You'll want to be sure you understand, again, who's owning that IP, what is going to be developed, and then how can you use that within your business. And if you're not owning the deliverable as a customer, do you have the right, through a license, to continue to use that deliverable in the way that you need to within your business, or to share it? Sometimes you may want to share that IP with another contractor. So if you going back to the software component example, if you receive that component into your platform, you may want to still be able to license that out if you don't own it, to another contractor that's also helping you, or to your customers, for example. So it's important to understand what IP is going to be developed and how you're going to handle IP ownership. And we like for that to live in the MSA. So it's more set in stone. It's harder to change than through each statement of work. Moving to allocation of risk and warranties and MSAs, these are typically shifted more towards the vendor, since they're the ones providing services. Although on the vendor side, of course, you'll want to provide less in terms of warranties and shift the liability back to your customer. But I mean, typically what we see is the vendor takes on more of the liability here. Liability caps can be a common way to manage risk in MSAs. They are usually, as Haley mentioned, subject to the payments that are made under an agreement, and typically involve 2 or 3 times the amount of payments that are made. Sometimes you want exclusions from that cap, though. So indemnity is a really common exclusion, especially if you expect IP to be developed under the agreement. If there's any infringement, say vendor provides this component to you, you now receive a claim because something in that code is infringing a third party's IP. Indemnity is a common exclusion from your liability cap because it's, one, really difficult to determine the potential costs of that litigation and how far it can go. And then 2, it's just a way to put that risk back on them to make sure they're doing their due diligence and what they're actually providing to you that you're paying for. And again, as I said, as a vendor, you're probably going to want to limit any exclusions that you have to your cap, and then limit the cap to what you're actually receiving as payment so that your risk is more in line with the value of the contract to you as a vendor. And then moving to the statement of work, these typically contain a clear description of your services and product that you expect to receive, the standard of service that you're looking for, any payment terms, since those often can change. Sometimes payment terms are in a separate exhibit if it's a more complicated structure. You'll want to include milestones and then your deliverables here too. Another key thing to think about is if the statement of work and the MSA conflict, say, for example, in the IP ownership terms, which one is going to control? Sometimes we see, well, more commonly, I should say, we see the MSA control. And then sometimes there's an exclusion in the statement of work if it explicitly mentions it, the intention is to conflict with the MSA, but we like for the MSA to be our master agreement. And that way it's also easier if, depending on who's negotiating the statement of work, it may be someone who's not part of the legal team. And so you want to kind of control your risk in the MSA and allow the statement of work to be not affecting your overall relationship. So another example here, just to put this into perspective, is going back to that software component. Say that component is going to be a payment platform within your software or on your website. Your statement of work is probably going to contain tech specs. There are in an additional exhibit, tech specs around how does the component work? When is it going to be delivered? How do you receive the source code from the contractor, and by what date? So all of those terms are great to live in a statement of work because they can change each time. Additional exhibits that you'll probably see in the MSA structure are data processing agreements and addendums, particularly important if you have personal data or confidential data that's going to be involved in this relationship. These DPAs will also cover breach response and remedies, and you may want to go into more detail in laying out each party's obligations, especially in terms of payment or if there's a breach, for these more heavily negotiated agreements. And then your statement, service level agreements. And these can be sometimes a lot more critical depending on the platform. So say it's like, for example, a HR platform like Workday, and they're providing like a critical function for your business. You may want to have higher availability, like 99.9% availability of that platform for your business. And you may want to have a higher level of credits and then termination rights in your service level agreement than you would in something that's like an employee reward platform that isn't as crucial to your business operations.
I have one practice tip is look out on service level credits, because even though it would typically be a positive thing to get a credit, you have to look carefully at the language, because often it's sort of a hidden liquidated damages clause. And, you don't want to give up a potential large claim for a small credit.
Good point. So let's move to our license agreements and our data sharing agreements. At a high level, these can also range from Category 2 to Category 3 agreements, where they can be heavily negotiated to being a completely bespoke agreement, like a patent license, given what you're actually licensing under the agreement. So first, you want to understand, what are you licensing here? Is it a data set? What's the realm of that data set? What's included in that data set? If it's patents, are there certain applications or child applications that are part of that, or granted patents? Is it limited to a certain jurisdiction that you can use it in? So again, going back to our scope of IP, like what is the realm of the thing that you're getting, and how are you ensuring that it matches like what you're actually going to need for your business? Are there any use limits here for development? Can you use it to develop different products that you need? Is it, for example, with a trademark license, can you use that brand and the packaging that you need if that's what you're licensing? Is this IP going to be used to create other products within your business that you're now going to need to out-license? So those are all things to consider in terms of what you're actually licensing here. Additionally, if it's data, is there any personal data that's going to be transferred across a border? Again, that would, like I mentioned before, the data privacy laws, like that can accidentally subject you to certain foreign privacy laws if you're transferring data out of a jurisdiction that requires you to keep it there. Like the EU is a big one for GDPR. And then what are your rights to modify whatever you're licensing and make derivative works off of that? If you're the licensee, are you owning these modifications? And if you do own them, do you have any use limits to that? Are you able to make derivative works of whatever you're licensing? Going back to like the product example, if you're in licensing patented technology to develop something internally, how can you use that internally and externally? So can you develop that to make a derivative work for your product and then go out and sell that to other customers and commercialize it? Sometimes oftentimes we see a licensor wanting to own those modifications, especially in contexts like a patent license, because it can relate to their ability to continue to patent and protect their IP. So if you're a licensee, you may not get that in a patent license. But if it's a data license, you may receive the right to own any modifications you make to that data set. And then the data owner might want a license back to continue to use it. You also want to consider your royalties and payment structure. How are you paying for this IP? Is it based on sales or revenue received? Is it a one-time fee? For warranties and liability related to the licensed IP or data that you're receiving, going back to the personal data example, we harp on that a lot because we see a lot of issues come up here. But are you buying this data set from someone who's received the legal consents to share it with you, and then also the consent for you to receive the data and then resell it possibly or incorporate it into a platform? So something to consider is how you're managing consents for the data that you receive and who's liable for receiving those consents. Additionally, infringement claims always come up when there's IP involved. So if there are any infringement claims in your license, who is liable for that? How are you covering the infringement costs? Are there any obligations around notice? If it's open source software, how would you like to handle that? If there's a warranty for no open source and IP that you've licensed that's software, if there is an indemnity to cover that but no warranty. So there's different ways to kind of structure around how you want to cover the liability related to that. And then lastly, for trademark licenses in particular, if you are on the licensee side, and I should go back to, so trademark licenses we see as sometimes just like a simple provision in an agreement. It's like a couple sentences, but sometimes we also see a full standalone trademark license. It really depends on what you're licensing. So in the small context, it could be you're licensing out your logo to be used on a customer's website. And that may just be a simple provision in your MSA. There could be a fuller trademark license that is for different, more broader uses and a larger commercialization. So from the licensee perspective, you want to make sure, again, your license matches what you need it to do for your business. Like, are you receiving the rights that you need to be able to use this IP as anticipated? On the licensor side, you want to ensure that you have quality control guidelines that are in place and that you're requiring your licensee to comply with. If not, they could potentially invalidate your mark, and that could be obviously a real problem. And then lastly, you want to ensure that any goodwill that is created from their use of that trademark is going back to you and you continue to own that. That's really important because goodwill is a crucial component of your trademark and its value, and you can't separate them. So you want to be able to continue to own that goodwill and make sure that it's going back to you. Okay, and last, we are going to cover consulting agreements. These tend to be more category 2. You're starting with a parties form. Sometimes they can be category 3 where they're more bespoke depending on what you're receiving, but often we see a form from the beginning here. Starting again with IP ownership, since it's always one of the biggest components of these agreements. What is your consultant developing? And then how are they able to use that outside of your engagement or not? So say you engage, going back to our software example, you engage a developer to develop a piece of software for you. Can they continue to use that code elsewhere for their other customers? Or can it only be used in your engagement? You own that and there's no license back to that contractor to use it elsewhere. So that's definitely a really big component here is who's owning the IP and how can it be used out of this agreement. Sometimes we also see a perpetual license as well. So you'll see like a perpetual license to the deliverables for you as the party engaging the contractor, and then the contractor can will receive ownership of that IP that they created, which is default law anyway. But they'll continue to own that, and then there are some use limits, like I mentioned, around how they can use it outside of your engagement.
One point on that is that the background laws for IP differ based on whether you're dealing with patents, copyrights, trademarks. And so, one important point of having all of these things covered in the agreement is you can align, if a party is to receive a license or to own it, you can align that with how you would choose that for your business interest rather than the background law. Joint ownership comes to mind, joint ownership of patents. At least in the U.S., there's no obligation to share your proceeds with your other joint owners, whereas in copyright law, you are accounting. So, and then outside the U.S., you can have different laws entirely. So, putting those things here in the agreement is important because, you're kind of setting forth, a rule by which you can align all of your IP and in every country.
Yeah, that's a good point. It's something we're seeing right now in one of our projects. So always good to lay out very clearly what the expectations are. Next, in confidentiality, this is actually more of a concern here, again, based on like the access a consultant will have to your confidential information and their ability to share work product with their other customers or outside of your engagement with them. Another piece here to consider too is how long those obligations last. Or is it a handful of years, 2 or 3 years after the agreement? If you're sharing trade secrets, you may want that to be perpetual obligations for confidentiality until it's no longer a trade secret. So those are that really comes up as more of a consideration in these types of agreements. Background IP. So sometimes a consultant will want to include their own background IP whenever the deliverable is that they're creating. This is obviously something that you can say, nope, we're good. We don't want that. We don't want the risk there. But if you do receive background IP as part of your deliverable, something to consider is, one, do you have the license rights to use that IP in the way that you need? And then 2, if there are any issues with that IP, which I'll cover later, how are you going to address that and who's liable for that, say like an infringement claim? The scope of services is also important to clarify in these agreements to be sure that you're receiving what you're bargaining for. And then when we're talking about warranties and liability shifting, the non-infringement issue really comes up in these agreements a lot because, for example, if you have a consultant that's like a kind of like a one-man shop, they may not have the financial backing to be able to cover indemnity costs if you're sued by a third party. So something to consider is how do you manage and shift that risk? Are they warranting to you that, the deliverable does not infringe, as well as providing an indemnity for that? Do they have insurance to cover that in case they can't pay for the indemnity? So how are you making sure that if something does go wrong, like, again, the open source example is such a common example that we see. If there is a claim for copyleft open source and the third party who owns licensor that owns that open source comes to you and says, you guys incorporated our code and now you have to disclose it because you've distributed out to your customers and your source code now needs to be disclosed publicly, which could be very damaging for your business. Who's liable for that? If it's one consultant, how are you going to handle that? There's just a lot of considerations there around protecting. And then again, as Haley mentioned, there's lots of ways you can protect that are not related to the contract, like audits and other like tech protections that you can have in your business. So to wrap up, we're going to go over a few market trends that we typically see in these agreements. First is the data processing agreements are becoming much more common, partially because there are more data privacy laws. There's more platforms and ways you can use personal data, biometric data. You can think of like AI platforms, for example. So using these agreements, even if you're just sharing confidential information with another party, given the landscape for cybersecurity risks and how hackers find new ways every day to get access to your information, these agreements are becoming more and more important to include.
Yeah, and I'll add. So, it's fairly recent development, last few years, where it's common to insist on these forms being attached to what would have been typically an 8 or 10 page form agreement that you're negotiating, and now you're handed a stack of 10, 15. There might be model clauses for sharing data across border. You're handed essentially what is even a more complex contract to review than what you started with, and it's on top of it. And so then the question is always, well, do we really need this here? And I think you have to sort of assess that, and it is a risk continuum. But to comply with the law, if you are going across border, or if their data is coming, or if it's coming from Europe, the answer is certainly yes. And if it's within the U.S., what's becoming more common is to take the terms that that were covered by the GDPR and to use those or similar terms to cover the various state privacy laws that are being adopted. And so all of that comes under what will either be called a data processing agreement, data protection addendum, or information security addendum. But what it does is it kind of replaces what used to be a paragraph or less, maybe a few sentences even within one of these agreements, and really ups the requirement for review.
Yeah, you'll also see cyber insurance requirements in there sometimes. So and that may be something that you want to ask for if you're providing confidential information to a vendor. You may want to be sure that they have insurance as well for cyber specifically. And then speaking of breaches and data privacy again, the liability caps and how you handle that can change. So something we're seeing more common these days is what's called a super cap. And that's like you have your standard liability cap for the entire agreement. Any claims under that agreement, say it's 2 times the amounts paid under the agreement. And then you have your exceptions to that, and those are uncapped. In the middle is a super cap, and that could be like 5 million tops or something like that, 10 million, and that only applies to breaches of your data privacy obligations. So it's a way to sort of limit, one, your exposure if you're a vendor, but also get a little bit more protection if you're providing that information. And then 2, it allows those obligations to be tied, or the liability obligations to be tied to your specific obligations under your data privacy terms and not just because you were breached and now you have like uncontrollable damages there. So it limits it more.
Yeah, and I would add, like, so then people will say, well, how do you figure out what your super cap might be? And usually what I'll say is, okay, well, if we know that there is an insurance policy, we know kind of the total dollars that might be available for that super cap as it relates to data privacy and security. What happens in the negotiation, they'll say, well, that's our cap for all of our customers, all of our claims. So you can't have the full limit of what our insurance cap is for your super cap, but it's somewhere in between there. And they have to assess, okay, are we going to have 100 claims under our insurance? Or are we going to have 10 or 5 or what might it be? But typically the push is for somewhere, in the middle of the range between what their max cap is on their insurance and what 12 months fees or 2 times 12 months fees might be under the agreement.
I've also seen too, calculating the individuals that you're providing data for. Sometimes you can't do that. That's pretty nitty gritty. But if you are able to understand like the number of individuals and the jurisdictions that they're in, that can help you understand those costs in those jurisdictions. Like GDPR has very specific amounts per individual if there's a breach. So that can also be another way to calculate that cap. It's a little time consuming and tedious, but it is an option. Another trend that we see a lot is restricting the use of anonymous and aggregated data. And typically that's, if you're going to use data within your project, it is often necessary for it to be anonymous and aggregated, so you can't tie it back to an individual. So
yeah, and I'll add to this. It used to be, I think that, vendors would think, well, this is just, free, we're taking your name off of it. We should just be able to take all of your user data and aggregate that and, improve our performance of our system. But even beyond that, if it's anonymous, they would think they should be able to offer that out to others, to resell it, put it out on the market, create a product that uses that data. And so I think those days are quickly disappearing. And now this is a more contentious part of an agreement. And more of our clients will say, no, you don't get access to our data, even if you anonymize it. Because then the question might be, how do you even know that you can't be de-anonymized? Or, what's the, how safe really is it in an anonymized format? So, overall, the market has really moved on this term, I would say, in the last 3-4 years.
And then last is something that we're seeing very recently is mass arbitration clauses in website terms of use. It seems very nuanced, but in other terms of use, we have seen website providers have a clause that state that if an individual has a claim, it has to be through arbitration. And then lately, we've been seeing more lawsuits that involve more like a class action size arbitration lawsuit. So arbitration was a way to kind of avoid some of those class action suits. And then now we're seeing these large arbitration cases come into play.
Yeah, I'll add, this is also a very recent development for which the law is not even yet settled, but yet we are, trying to, as the laws are being settled, come up with language that can protect the client. And this is really, I think we're thinking more from the perspective of we're building a customer set of terms of use that goes on their app or on their website. But what we're looking to avoid there is allowing the plaintiff's attorney to then solicit a number of people to come forward and bring 1,000 arbitration or more arbitrations at the same time, in which the plaintiff's attorney gets a third of recovery and everybody else gets it, like in a class action situation, a small check. And just the expense in dealing with this is, what we're trying to avoid.
So in summary, the common tech agreements that you're probably going to see are these form agreements, these somewhat negotiated MSAs and consulting agreements, and then your license agreements, your more bespoke agreements. And make sure you understand where you're working, what your high-level considerations are, and then your key terms, and then move forward with preparing the next steps for that. That's it.
Thank you. I guess we don't have any questions.
Yeah, we didn't get any questions from the chat. So I appreciate everyone for coming today. And As I said at the beginning, a copy of the presentation and the deck will be available in a few days. And thanks again, everyone, for participating today.